start, I guess. I know we're waiting for one person.
It was wonderful.
Hi, Anthony.
Good morning.
How are you?
Great.
How's your dad?
Oh, he's great.
Good.
Yeah, he says hello.
Okay. All right. I think we're going to get started here. Thank you, everyone, for coming, and thank you to our panelists. We're here on a very important matter, and that is the Supreme Court. We know that we have not had a court opening since the Civil War that's lasts longer than a year, and unless we have a hearing and a vote, that is where we're headed. This is a pretty serious matter. We've had a number of cases come up before the court that it looks like there'll be really no decision on, and it's my view that 8 is not enough, the opposite of that old TV show that some of our colleagues seem to be spending time watching. We have some great experts to talk about this important subject, but before I turn to them, we're going to hear from Senator Reid.
Amy, thank you very much for your diligent work here. Every Wednesday we come here at this time and are educated, and that's her job as the head of the Steering Policy Committee. So she does a wonderful job. She has this meeting every week and intersperses it with other meetings during the week on occasion. It's a lot of work to put these things together, and her work is exemplary. So I appreciate that very much. I'm looking forward to hearing from each of you. The issue that's before us is an issue that affects our country, each of our states, and frankly, the world. People from around the world are looking at this Republican presidential race, just can't believe what's going on. And we can't either, because it's spilled over into what we're doing here in Congress. So we look forward to hearing from you. We know how important this issue is, and again, I'm confident we'll learn something here today.
Thank you very much. Any of the others? Senator Durbin from the Judiciary Committee, Senator Stabenow.
I'm sure that you're going to introduce my fellow Illinoisan here, Carolyn Shapiro, Solicitor General of our state, from the city of Evanston, and I'm happy to have her here today. And I want to apologize in advance for leaving in just a few moments. I have an appointment at 9:45 with a graduate of Niles West High School, Skokie, Illinois, who is aspiring to fill the vacancy on the U.S. Supreme Court, Merrick Garland. You know, I'm looking forward to meeting with him, and I'm glad that some members on the other side are meeting with him. And I think that is creating a problem for them because he's so extraordinary. What he brings to this job, what the president saw in him, makes him obviously a qualified candidate, and makes it even more difficult to rationalize why, for the first time in the history of the United States, the Republican-controlled Senate wants to deny this man a hearing before the Senate Judiciary Committee. I hope that as they reflect on it and with their own conscience and their own values, they'll reevaluate where they stand today for the good of this nation and the court. Thank you.
Thank you. Senator Stabenow.
Well, Senator Klobuchar, I just want to say, first of all, thank you to you for your diligence, not just today on this topic, but continually. Thank you very much. And I just wanted to share, and I'm sure colleagues have heard the same thing, but the last couple of weeks, not being in session and being at home, I had so many people from Michigan coming up to me, just stunned that a group of people, the United States Senate, could decide not to do a major part of their job for a year. And what folks said to me is, you know, I'd get fired if that happened to me. And how can people in the Senate decide they're just not going to do part of their job for a year? And so I think for the average person, that's the question, is how do you do that when under the Constitution it's so clear what our responsibilities are. So thank you to everyone for being here today. And I know folks in Michigan are scratching their heads about what's going on, and they are hoping that United States Senate will do its job.
Thank you very much, Senator Stabenow. And we've also been joined by Senator Kane and Senator Coons. And I think we'll want to hear from them in a little bit, but maybe we'll start with a few of the people that have joined us from all over the country. And one of the points that we're here to make today is that the fact is that there are circuit courts all over the country that await decisions from the Supreme Court, and you can have one decision in one district and another decision in another, and it's the Supreme Court jobs to make that decision. And without that kind of high court being able to make those rulings, you can't have consistency for our states and for our local government. So with that, we will turn it over to the Solicitor General from the state of Illinois, Carolyn Shapiro.
Thank you very much for this opportunity to talk with you about the importance of a fully functional Supreme Court to state and local governments. As you said, I'm Carolyn Shapiro. I'm the Illinois Solicitor General. I am also a tenured faculty member at IIT Chicago-Kent College of Law, where I founded the Institute on the Supreme Court of the United States and where my scholarship focuses on the Supreme Court as an institution. As Senator Klobuchar said, of course, state and local governments rely on the Supreme Court to provide clarity and certainty in numerous areas of law where there may be disuniformity. Many of these areas of law are not the headline-grabbing, hot-button issues that we hear about in the news, but nonetheless, in some of these areas, the risk of an equally divided court is real. I could talk about a lot of different areas, but what I'm going to focus on here will be the Fourth Amendment. The Fourth Amendment, of course, regulates what law enforcement can and cannot do in investigating crime, and it protects the privacy interests of the citizenry. It is crucial for law enforcement to know what the rules are, and it is crucial for the citizenry to have confidence that law enforcement is following the rules and is doing so uniformly. And these things can't happen without the Supreme Court to resolve some of the difficult and contested questions in this area of law. In the past 3 years, the Supreme Court has decided at least 8 Fourth Amendment cases by close votes. And in several of those cases, Justice Scalia was in a 5-member majority. In other words, without 9 justices, the court might well have been unable to resolve the issues presented in those cases, leading to ongoing uncertainty. And some of those cases, as happens in the Fourth Amendment arena, have created new areas of uncertainty that must be resolved, but that may require a 9-member court to do so. I'm going to briefly mention 2 such areas. In 2013, the Supreme Court decided Florida versus Jardines, in which Justice Scalia wrote the majority opinion on behalf of a 5-justice majority. Jardines held that when the police bring a drug dog onto the front porch of a single-family home, that constitutes a search for purposes of the Fourth Amendment. This holding has led to new questions. Earlier this year, the Illinois Supreme Court held that Jardines extends to a drug dog sniff outside an apartment door in the common area of a apartment building. But in similar cases around the country, other courts have reached different conclusions. So not only can this lead to inconsistencies in the law from state to state, but it could even lead to inconsistencies within the jurisdiction. Although the Seventh Circuit, our federal appeals court, has not ruled on this question, it is possible that the same search would be held unconstitutional in a state court but constitutional in a federal court, or the other way around. This kind of uncertainty is untenable. A second issue involves the implications of a 2013 case of Missouri versus McNeely, in which Justice Scalia joined a 5-member majority to hold that the natural dissipation of alcohol in the blood does not in and of itself create exigent circumstances allowing the police to obtain a blood test without a warrant. This term, the court is poised to hear a case, Birchfield versus North Dakota, about the implications of some of the reasoning of McNeely for state statutes that criminalize the refusal to submit to a blood test when pulled over for a DWI. Now, Illinois doesn't have that statute, but we do have a statute making a refusal to submit to such a test grounds for suspension of a license. And a case challenging that statute is being held by the Supreme Court presumably for its decision in Birchfield. So if the court is unable to resolve Birchfield because it is equally divided, or is unable to resolve our case should it decide to hear it, these statutes will remain under a constitutional cloud, and neither law enforcement nor state legislatures will know the scope of their authority in these areas. There are, of course, lots of other areas of law I could discuss, but the point is that state and local government, law enforcement, and the citizenry depend on a functional court to provide clarity and certainty in areas of law that affect people on an everyday basis. Thank you.
Thank you very much, and my colleagues should feel free to ask questions if they want to. We have less people than usual attending because we really wanted to dig into some of these issues in terms of our experts, and so this is great to have. We also have a lot of our colleagues here. Senator Merkley is here. Senator Shaheen has joined us, the vice chair of the steering committee, and Senator Whitehouse, who also serves on the Judiciary Committee. Maybe Senator Kane.
Amy, before I have to leave, I'd like
Yeah.
to hear what Iowa has to say.
Okay.
Is that okay?
That's right. That's my neighboring state of Iowa. We know a lot of good things happen in Iowa. Sally Pederson is the former lieutenant governor of the state of Iowa. We were together yesterday, and I know she has some things to say about what happens when local governments don't know what the decision is going to be of the Supreme Court for 2 years.
Thank you very much, Senator. Well, first of all, I'd like to say that we met yesterday with Senator Grassley's staff and his chief counsel for nominations, and I'd like to tell you a little bit more about that later.
You didn't meet with him?
No, we were not able to meet with him, but with 3 of his
For me to
senior staff.
understand that.
There were 10 of us from Iowa, and we represent kind of a broad range of interest groups and activists. I co-chair, along with my colleague, the Republican former Lieutenant Governor of Iowa, Joy Corning. So we co-chair an organization called Justice Not Politics. It's a nonpartisan organization that's been in existence for a number of years, and it was formed to keep Iowa's courts impartial and fair. We really believe strongly in judicial independence. And so when this federal issue came up, and we saw that there were extremist views here in the nation's capital concerning our courts, we felt we needed to become active in this as well. And so my Republican colleague, Lieutenant Governor Joy Corning, and I have held press conferences. We've done shared op-ed pieces that have appeared in the Des Moines Register and elsewhere. And as a number of other activists in Iowa, we are trying to urge and persuade Senator Grassley to hold hearings. What we learned from his staff yesterday is that he has 3 reasons that he is not willing to hold hearings, and those are that he knows that the nominee could not be confirmed. We don't know how he knows this, but he knows this. He believes that he is being a check on our president, and he wants the people to weigh in. So we obviously had responses and answers to each of these 3 arguments, but I can't say that we persuaded anyone in the room. We will continue our efforts as Iowans because we feel so strongly that judicial independence is essential to our democracy, that if we undermine the public's faith in our courts, we undermine democracy. So that's why I'm here in the Capitol today, and why I'll continue, along with my Republican colleague, to fight this fight.
Very good. Thank you very much. Senator Kane, did you want to?
Just a couple of thoughts. I was a civil rights lawyer for 17 years, and then my wife was a judge, and I was a mayor and governor, and often had statutes or ordinances tested by the courts, and so I know the chaos that can be created with a situation like we have. But I came in when Senator Stabenow was just saying the Senate should do its job. Why would the Senate not do its job under this circumstance? Why would we cut against all past precedent and say that, you know, we're not going to even entertain a nominee? And there's 2 reasons, basically. The first is it's about this particular president. This particular president being treated differently than any other president has been treated. Fundamentally respect for this individual. It's not about Judge Garland because they announced their position before his name was on the dock. And so that issue, that it is a disrespect to this particular president, President Obama, is not lost on my constituents, Democratic, Republican, or Independent. That's what this is about. And the American people understand that. and I think it is just outrageous. The second thing it's about is, and we've seen this in other instances as well in the Senate, it's kind of an anti-accountability strategy. Wait a minute, we Republicans, if we voted no, so if the Chair Grassley wants to be a check against the president, great, he can vote no. And if they vote no, that is consistent with the advise and consent clause in Article 2. But what they want to be able to do is not vote yes or no, and then think they can evade the accountability to the American public for their vote. The last thing I'll say that I think is very powerful is the precedent that's being created in this. The Republicans say the precedent is, well, we're doing this because it's the last year of an administration. But there's nothing in the Constitution that conditions anybody's powers, Congress or President, on the last year of an administration. The precedent that they're creating is if you do not like the president, you never have to take a position or even take up a president's nominees. That will be deeply destructive of all three institutions, judiciary, president, Congress. They will live to regret that precedent, and they should pull back from it.
Amy, you know, I may be old-fashioned, okay? But I can't imagine, just speaking from a personal perspective, I was about the same size as the state of Nevada with people. What did I say?
As Iowa, you said.
Yeah. I said what?
You've meant Nevada are the
Okay.
same side as
No,
Iowa.
Iowa was about the same size as Nevada,
Yeah.
okay?
Oh, I misheard.
Okay, so that's what I said. And if I had 10 people from Nevada wanting to come to see me, I would do everything I could to make sure that happened. I wouldn't have the nerve to stand up 10 Nevadans and in the nation's capital who came to see me. So I don't understand this. I totally don't understand what's going on. We know that we had one senator from Kansas who had the audacity to say, I think that we should have a hearing and I think we should vote. And because of the Koch brothers being from Kansas, I guess, he backed down from that. Again, I can't imagine my not meeting with 10 people that wanted to see me coming from Nevada, certainly with notice that they were going to be here. And I can't understand how I could, in front of the people of the state of Nevada, after having become very public on an issue that's important to the country, back down from it. That would be beyond my ability to understand how I could do that. So I don't understand what's going on here. I do understand that it appears that there's a lot more involved with money, and that is people are so afraid of the Koch brothers and people situated like them that they're afraid to do their jobs for fear that they'll have a primary. That's what they've threatened against Moran. I have no idea what Grassley's afraid of, but unless it's the Republican leader.
Senator Shaheen.
I just wanted to ask Ms. Pederson if you could talk a little bit more about the organization Justice Not Politics, and have you actually weighed in as an organization on what's happening with the Supreme Court?
Yes, we have. And Justice Not Politics is a nonpartisan organization. It's a coalition of both organizations and individuals. It includes groups like the League of Women Voters, the Interfaith Alliance, many organizations that simply believe in judicial independence and want to keep politics out of the courts. And those people have been very active in signing petitions, in showing up at town hall meetings. As you may have read, when Senator Grassley was in Iowa during the recess, he usually holds quite a few town hall meetings. He only held 3 town hall meetings, and they were all held in very, Republican districts. Still, there were people at those town hall meetings who questioned his refusal and to hold hearings and his obstructionism. And as I understand, he now plans to meet with the nominee, with Judge Garland. So I think that we are having some impact. There have been strong editorials in the newspapers urging him to hold hearings and to do his job. And so I think we intend to keep up the drumbeat because this is so important to our nation.
Thank you.
Maybe if I could. Senator Klobuchar, thank you. I just wanted to comment on three things, if I could. First, the point that Senator Kaine made about a accountability avoidance tactic. When my predecessor, now Vice President Biden, but then Senator Biden, was chairman of the Senate Judiciary Committee, every nominee got a hearing and got a vote. And even those nominees for the Supreme Court who failed to get a majority vote out of the Senate Judiciary Committee advanced to the floor for a final vote. Despite some frequent misquoting of one speech that he gave back in '92, the record of then Chairman Biden is very clear that every time a president nominated someone, advice and consent on a bipartisan basis was understood to mean meeting with the nominee, holding a hearing on the nominee, and taking a vote on the nominee. And by refusing to even meet with the nominee or hold a hearing, I do think, Sally, to your point, we're setting a very bad precedent for democracy as an institution. I serve on the Foreign Relations Committee. I've had the opportunity to meet with a number of heads of state in developing parts of the world where they have copied our Constitution or have adopted a constitutional structure that's very close to ours, but where their judiciary is not independent and is not free of obvious political manipulation. And for us to continue to be an advocate for a strong and independent judiciary is at some risk when we have such a blatantly politicized process of refusing to engage in even the most minimal steps of advice and consent. And then last, to Carolyn, to Solicitor General Shapiro, I was responsible for a local police department for a decade and know all too well how very closely you follow the developments in courts and how difficult it is to engage in effective law enforcement when you're unclear about exactly where the boundary is. And so the result may be a less safe public, a less engaged or proactive policing strategy, or less clear rights for those who are criminal defendants. I think you point out importantly that the Supreme Court is rendering judgment over and over and over in a very wide range of cases. Some of them are well-known and highly political, but many of them are not as well-known, and they affect everything from commercial litigation to the regular actions of local government week in and week out. For the Republicans in this body to refuse to do their job and to conduct advice and consent in the most minimal way is outrageous and is something that we should all be speaking out against, and I appreciate your presence here today.
Thank you.
And I think that point, for those of us that serve on the Judiciary Committee, I know that Senator Whitehouse wanted to say a few words. We really have to do some soul searching about what would we do if it was a Republican Senate, a Republican president, and a Democratic Senate. And I've come to the conclusion, with a year left here, I would have certainly gone forward and met with the person and had hearings. I don't know who the person is, so I can't say how I would have voted. But it's just outrageous to the entire nominations process and to the Senate if we keep this up. So, Sheldon, did you want to?
Just briefly to echo Senator Coons's point, we identify ourselves in the United States as the leader of the free world. We operate by constitutional processes and procedures. When there is disorder in the constitutional process of nomination, and I think this is disorder in the constitutional process of nomination, that sends a signal of alarm to some degree, I think, out into the country, into the markets, into the rest of the world, and we don't, as America, get away scot-free with creating unnecessary disorder, and it's hard and wrong to pretend that when we create artificial unnecessary disorder, that happens without any consequences.
We want to hear from Bill Marshall, and then we'll hear from Jeff. Bill Marshall, who is the former Solicitor General for the state of Ohio.
Thank you, Senator Klobuchar. I am the former Solicitor General of the state of Ohio. I now teach at the University of North Carolina Law School, and in order to ingratiate myself with two members of the panel, I should point out I started my practice at the Minnesota Attorney General's office, and I'm a native of Nashua, New Hampshire. So, so I'm doing everything.
You covered
I'm doing everything I can to cover myself.
I guess that's why we invited you.
Where's the Rhode Island bit?
I love Rhode Island, home of Dunkin' Donuts. So let me follow up by echoing a lot of Solicitor General Shapiro's remarks about the need for stability in law, because not having the ninth justice doesn't just affect 4-4 decisions. It affects what decisions the court's going to take on certiorari. it creates that kind of confusion that Solicitor General Shapiro was talking about, in which there can be divergent issues on the same, divergent opinions on the same issue from state to state, from district to district, from Court of Appeals to Court of Appeals. And this doesn't also just involve litigation. It also involves giving advice. And those of us who've worked in Attorney General's offices know that we have to give the government advice. And if we just say this is up in the air right now, we're not giving government officials at the state level the kind of direction that they need in order to be able to do their jobs properly. So what I think is happening with keeping this vacancy open is that it really is limiting the ability of state government officers to do their job in the best manner possible. If it's okay, I'd also like to mention something about Judge Garland, who I know a bit, because I think Judge Garland is the perfect kind of judge you would want on the Supreme Court based on his reputation if you're working for a state, really working for everything. He is a person who is noted for building consensus, which is something that also helps stability of law, and having a justice of that type who works across ideological boundaries to come together with a single opinion is immensely important to the rule of law. He commands respect of people across the ideological spectrum. You saw what Chief Justice Roberts had to say about him, and even what some conservative commentators have said about him. So he's actually, I think, the perfect person at this point in history to be appointed to the Supreme Court because of his ability as a consensus builder. Finally, I teach constitutional law, and I just have to add one other point. I've read the Constitution. It says a president serves for 4 years. Even the 22nd Amendment says he may be limited to 2 terms, but that doesn't end on the 4th year of his 2nd term. He is the president the entire time. And if we started adopting a constitutional system where people are disallowed from doing their job the last year that they are in office, that would affect the Senate, not just the presidency. Mm-hmm. And what we're seeing here, I think, is a really derogation of the duties of the Senate to work with the president to try to fill an important hole in the government.
Thank you. Senator Merkley.
So I thought it was helpful to go back to the Federalist Papers to read about the debate on how this was constructed in the Constitution. And there were folks who wanted very much, as they referred to the Assembly, that is Congress, to do the appointment process as a check on the executive. Others who felt it should rest with the president, there'd be more accountability. And ultimately, this compromise, and as Hamilton described it, he said the point was a check on a president who appointed people of unfit character. Unfit character was the key, and you can interpret that a variety of ways. You can interpret it in terms of experience or in terms of temperament, but that's our job, and that's the job laid out in the Constitution. And I thought it might be helpful, I don't know if that's one of the arguments you've taken to the senators, remind them why this was constructed this way, and that essentially it was in the view of 3 co-equal branches. But if the Senate takes its advice and consent function and decides to start systematically failing to exercise the discretion of judging whether someone's of unfit character, then you don't have 3 co-equal branches. You have 1 branch undermining the other 2 branches. And so that's clearly out of that practice is out of sync with the Constitution on several different important levels, and just feel like we have to appeal to our colleagues' responsibility to honor this framework in the Constitution, honor the 3 co-equal branches, honor the responsibility to decide if somebody's of unfit character or not. And that requires vetting and voting. I am concerned that if this Republican strategy succeeds, and for example, there's a President Cruz, and he appoints someone to the right, and someone to the right is put onto the court, then what happens down the road when there's another vacancy, and maybe now the Democrats are in charge of the Senate? Well, I come to this saying, at this level right now, absolutely we must honor this constitutional framework. But then if one side uses their powers to pack the court, then what happens? And this is where Tim Kaine referred to the precedent. Now, does the other side need to use their powers to pack the court in order to rebalance the Supreme Court so it can be restored as an institution? In other words, this is just a formula for absolutely degrading, politicizing destructing the integrity of the court. And that is something that none of our colleagues should be part of. So I'll just throw those other points into the conversation.
Very good. Thank you. And Senator Shaheen.
Well, I just wanted to pick up on something that Mr. Marshall said, and I know Ms. Pederson will identify with this, and maybe some of you saw it in the clips in the last couple of days, but there was a high school student in Iowa who wrote a letter to the editor talking about the question of should there be action in an election year on an issue like the Supreme Court, and he suggested that if we weren't going to be able to vote on a Supreme Court nominee because it was an election year, then perhaps Senator Grassley, because he's up for re-election and this is the last year of his term, shouldn't be in the position of chairing the Judiciary Committee to act on this nominee. So it really does lead to a very slippery slope of where, what's the line? If you say we're going to do this, then next time around, if it's the next to the last year of a presidential term, do we say, well, because we're in the 2-year election cycle, we're not going to consider that nominee? I mean, there is no end to how this can be interpreted if this is a precedent that we allow to continue. So it is, as everyone has said, very dangerous to our democratic process, and it should not be allowed to continue.
Thank you. Now we're left with 2 M states here. William Smith, who is a member of the Maryland House of Delegates. Thank you.
Oh, well, thank you for having me here. Will Smith, member of the House of Delegates representing Montgomery County, where the Chief Judge lives. And so thank you for inviting me here today. I feel like I've been offered a seat at the grown-ups table from being from Annapolis. But I'm here to offer my perspective and my voice to the growing chorus of folks that have already articulated why this is important. Since 1916, every justice, every nominee has had the opportunity for a hearing. 17 have been confirmed during the last year or during an election year of a presidential term. So this is something that's unprecedented, and it's something that obviously needs to be addressed. But I'm also here to offer my perspective as a state lawmaker and to touch on some of the issues that have already been brought up by the Solicitor Generals with respect to privacy issues in lawmaking. In Maryland, we're going through justice reinvestment. We're completely reworking our criminal justice system. And in that process, a lot of federal implications come up. Privacy issues come up. We're working with body cameras now, and we're dealing with the storage of footage. And a lot of the times, you're capturing the worst moment of someone's life. We're dealing with a lot of privacy issues with respect to who gets access to that video footage. Serious Fourth Amendment implications. All the way through consumer protection. We're dealing with a lot of preemption issues. We look to the court for that type of equal application of the law. And when there's a 4-to-4 split like this, which if you wait until the next presidential election, until after that, you're looking at almost 20 months or more before you get that next justice in place to lend some sort of streamlined guidance that you all can offer to the state and local lawmakers so we can go about our business in making laws at the local level. So this is serious implications that rise not only from the federal level, but all the way down to the state and locals. We really look towards the Supreme Court for guidance with respect to our piece. So I want to thank you all for having us here and allowing me to express our views from the state and local level. So thank you all very much.
Thank you. Thank you. And we've been joined by Senator Warren, who knows a little bit about law. So maybe we will first hear from the former Solicitor General of Montana, Anthony Johnstone. I worked with his dad for many, many years at my law firm in Minnesota. So we welcome him here, and then we'll hear from Senator Warren.
Well, thank you, Senator Klobuchar, one of my inspirations for going on my path to law school, as she knows. And thanks to the committee for this opportunity to join this important discussion. My perspective, while I currently teach constitutional law and on the Supreme Court and on the law of democracy at the University of Montana, my perspective is based on my prior career as a defender of the state's roles as laboratories of democracy. For 7 years, I represented the state of Montana in constitutional litigation as a civil servant under 2 different attorneys general. I defended our state laws passed by Republicans and by Democrats from state trial courts to the United States Supreme Court. And one thing I learned from this work is that the rule of law does not wait for the next election. Whether to vindicate an individual right grounded in our Constitution, or just as importantly, to confirm our collective powers to address pressing issues through the democratic process, the American people deserve justice without denial or delay. Yet today we're facing such a denial and delay of justice. As has been said, never in our entire national history has the Senate denied an elected president the appointment of a justice nominated prior to the election of his successor. If the Senate does not do its job to act on the president's nominee, the Supreme Court cannot do its job to resolve some of the most divisive legal issues we face in the states, some of which we've seen have already been splitting the court 4-4. It's a dysfunction that would persist until at least October 2017, again, the longest time since the Civil War. The impact extends well beyond the dozen or so cases where the court splits 5-4 or now 4-4. As Solicitor General Marshall said, it extends the certiorari process. It extends to lower federal courts and state courts that are looking for guidance. And it extends to those of us in the states who must decide whether to defend or prosecute under certain laws, or even whether to enact or reject certain laws based on the guidance that the Supreme Court provides. And Montana has cases right now in the pipeline that turn on all of these issues, whether it's regarding the denial of tax credits under our Constitution to religious schools, under a case that already has been postponed until the fall, that will be controlled by a Supreme Court case that's delayed. A challenge to our campaign contribution limits, which is currently controlled by what I view as a misguided decision of the Ninth Circuit Court of Appeals, and that ought to be corrected by the Supreme Court. And finally, of great import to us is the fate of the Clean Power Plan, which again, one of Justice Scalia's last acts was to stay that plan, which will now sit in limbo without guidance from the Supreme Court, perhaps as long until the end of 2017. Given these stakes, we should closely examine the arguments of those who oppose so great denial and delay of justice. The argument, as far as I can tell, sound in popular sovereignty, that the people should have a voice. And of course, arguments from democratic legitimacy are powerful in American law. But for that legitimacy to exist, we must be clear about the mandate that is sought from the people. What does giving the people a voice mean? Well, for more than 2 centuries, what this has meant is that an elected president's mandate includes the power to fill vacancies on the court until a successor is elected, and sometimes even after a successor is elected, if we look to our great Chief Justice John Marshall. The American people elected the president and the Senate based on this practice. Now it's suggested we should change the rules. If giving the people a voice doesn't mean what it's meant over our entire history, we should seek clarity on what it might mean. Does the election of a Republican president, Republican Senate vindicate this unprecedented exercise, despite the fact that those of us in a third of the states, such as Montana, have no opportunity to vote in the Senate election this year? On the other hand, if a Democratic president and Democratic Senate is elected, does this mean that the Republican minority would acquiesce? Is the filibuster off the table? We should seek some clarification on exactly what mandate they are seeking. And of course, if after that happens, they confirm Judge Garland, for example, it's hard to see how that's a principled rather than partisan line that the leadership is drawing. If it's a Democratic president or a Republican Senate, does that vindicate the president's nomination or the Republican's leadership? And if it was a Republican president and a Democratic Senate, who does that repudiate? This shows the trouble with departing from the historical convention of letting the people decide through the election of the current president. It's hard for the people to know what they're really saying if the people have a voice in the process, if we're not going to follow this longstanding practice. Even when the apparent mandate is clear, however, there's a risk that in holding a referendum on judicial nominations, instead of working in good faith through the cooperative process of 2 branches the Constitution contemplates, we will undermine the Supreme Court's role as an independent, equal branch of government. Allowing any branch to manipulate the court to its own partisan ends is a danger we have seen before. We're in a room named for the great Montana senator pictured behind me, Senator Mansfield. I'd like to speak about another courageous Montana senator who in 1937 took on his own party leadership when President Roosevelt threatened to pack the court. He said at the time, "Create now a political court and you have created a weapon that can cut down those guarantees of liberty written into your great document by the blood of your forefathers." I think we should hope for similar courage to depoliticize, de-weaponize the nomination process in today's Senate leadership.
Very good. Well, thank you. That was great. Impressive. Senator Warren and then Senator Blumenthal joined us as well.
Thank you. And thank you all for being here and talking about the implications of what's happening right now with the Supreme Court nominee. You know, we all try to make the same point. The Constitution is clear. Article 2, Section 2 says the President shall nominate, the Senate shall give advice and consent. The President has done his job. He has nominated someone to the United States Supreme Court. Now it is time for the senators to do their jobs. There is no legal precedent for what the Republicans are now doing. And let's be clear, advice and consent does not mean we want to hold the spot vacant until someone more to our political liking is in the presidency and can make a different nomination. No, advice and consent means we have hearings, we consider a nominee in good faith, and then we have a vote on that nominee. Maintaining a vacancy is nothing more than naked politics. It has no legal foundation. It has no principled foundation. This is naked politics, start to finish, side to side, top to bottom. And that's why it is that we're here to say that the Republicans in the United States Senate should just do their job. They need to put their oath of office ahead of their party politics. So thank you all for being here. Thank you for talking about the impact on people all across the country of the Republicans' failure to do their job. Thank you.
Thank you very much.
Well, I just wanted to say that, to their credit, there are 2 Republicans who have said we should go forward with holding a hearing and having an up or down vote. And I think they have been willing to take the initiative and say what's going on is wrong. And hopefully their colleagues will follow suit, because this really is, as you have said, Mr. Johnstone, you have said, this is a profiles in courage moment. Are we going to have the courage to do what's right for the country, or are we going to follow in the partisan footsteps of the leadership in the Senate?
Well, and one more thing I'd add before you get to Senator Blumenthal, as Mr. Marshall talked about Judge Garland and his strengths as a nominee. Well, not only are we have a few that have called for hearings, we have a number of senators who have actually voted for this nominee in the past. We have Senator Hatch, who actually went to the floor at one point when this nominee was up for the DC court, and actually said, I challenge people to come to the floor to say anything negative about this nominee, because in fact he's someone that's been seen, as you've said, Bill, as someone who brings people together. I asked him about that when I met with him, and he talked about the fact that he looks for that common ground, and he sometimes looks for narrow rulings because he believes people evolve, their decisions may change in the future, and that you try to get that common ground, that common point, so you can have agreement beyond the partisanship that, as Senator Warren was just referring to. So in that way, not only do we have some senators, number of senators meeting with him, we have a number of senators that have called for a hearing, a few that then have changed their minds, and we know why, but then we also have had senators that have actually supported him and voted for him and said very positive things about him. Senator Blumenthal.
I want to thank all of you for being here and the great work that you do, often unheralded and unappreciated, in law enforcement, which I did for a number of years. How many years was I Attorney General? 87. And by the way, I argued 4 cases before the Supreme Court.
Every 20 years.
And I can tell you the most nerve-wracking, challenging experience of a lifetime was to argue before the Supreme Court. I was also a law clerk, and I was always haunted by a story that Justice Blackmun told me about the advocate, he wasn't an attorney general, who went up to the podium to argue his first case, and he fainted, passed out. So whenever I approached the podium of the Supreme Court, I had in mind. That was his first and last argument. But I mention that point because there have been a couple of stories recently about the change in the functioning of the Supreme Court because it only has 8 members. And when there's the prospect of a tie, it affects the cases that are accepted. It affects the way cases are considered. It affects the numbers of cases. The numbers of cases have dropped dramatically over the last 15, 20 years that the Supreme Court considered, from 175 to now 75 over just the last about 10 or 15 years. So the Supreme Court as an institution is changed because of this vacancy. And when it lasts for 2 years, the vacancy is open for 2 years, as it will be if we don't confirm someone now, it will affect our whole democracy. And that's the message that we need to get to the American people. If we reduce the numbers of senators or congressmen by 1/9, if we change these institutions in ways that were never intended, we do grave damage. We undermine the credibility of the court, and its credibility is the only reason its decisions are enforceable. It has no armies. It has no police force. It is an anachronism in a democratic government, unelected, lifetime appointees, but people have trust in it, and I think that's what we're sacrificing. So the implications at your level, which I know only too well, having been a state attorney general, when you have uncertainty and instability in the rule of law, it affects the entire court system. It affects law enforcement generally, and I want to thank you for getting that message out. This is not just some abstract, hypothetical law school debate about, what does it mean, advise and consent? It's a shall advise and consent. It's not discretionary when you think it's politically convenient, when it's to your advantage. It's advise and consent. That's our duty. That's our job. So I really want to thank you. Thanks.
Very good. Senator Schumer and then Senator Franken.
Right. Sorry to be late. I have a good excuse. My daughter is getting married in 10 days. Her younger sister's maid of honor, and in her softball game last night, pulled her hamstring. The whole family's in, particularly my wife.
Anybody?
And what has that? Why did that cause you to be late to our meeting? I'm just trying to.
Because my daughter's in San Francisco, is trying to find some doctors.
Oh, I see. Okay, very good. Well, this all makes sense now.
Anyway, I just wanted to say one brief.
Senator Schumer is a man of many, many skills and abilities.
In any case, I wanted to just come in briefly. I did want to come in and thank you for coming. And the role that you can play in speaking up in your states is enormous. Thank you. The only point I wanted to make is this. We saw what happened a couple of days ago. It was alluded to by Dick and I think Jean. And that is, we had one of our senators who thought it was a very good idea to have a hearing. And he said so. And a day later, the organization by the funded by Koch brothers announced that they would spend $10 million against him in a primary. And unfortunately, he changed his mind. So I think one of the things we ought to remind people is when our Republican colleagues say, let the people decide, they mean 2 people, Charles and David Koch. And this is what we're up against. But the public's on our side, dramatically, moving in our direction. Independents feel more strongly about this than Democrats. And I believe that it'll be inch by inch. It's not going to happen in one revelation in a week or 2. But we're going to win this fight. And your role in it, spreading the word and talking about how important it is to our legal system is instrumental. So I thank you for that.
Senator Franken.
My excuse for being late is that I have a Minnesota breakfast every Wednesday, and we had 140 people today. So that took a while. So I don't know what the discussion has been, but there are a couple of ironies that I've cited here, that they say let the people decide, people did decide in the 2012 election. Then they've also said, a number of them have said, let the people decide unless they decide wrong, which is if they elect a Democrat to be president, then we'll take up Garland in the lame duck, which at that point you've just sort of abandoned any pretense that this is based on principle. And in a judiciary executive meeting, business meeting, I just asked them I said, do you guys talk to each other? Because they contradict each other so often. You know, this is the first time since we've started hearings that someone's been denied a hearing. And I just think the American people have to keep hearing that, and I think when they do, they'll be pushing for this, and I don't know where it's going to lead. And with events like the one Senator Schumer alluded to, it sounds like it's going to be very hard, but I hope there's a price to be paid for that.
Well, I think we're coming to an end here. Thank you, Al. Any other comments from all of you about what you've heard today? Sally?
I have one more comment, and that kind of comes back to the point that Senator Shaheen made and Senator Kaine, and that is this disrespect for this president. In our discussions with the staff at Senator Grassley's office, you know, they refer to President Obama as being lame duck, and so we had a conversation and a debate about when does the lame duck session start, and we always interpreted that as between the November election and the inauguration of a new president. But the staff person said, well, he's a lame duck because he's term limited. So I think that means that after he was inaugurated for his second term, he became a lame duck in the eyes of.
Actually, after he was elected.
Yeah, and so, you know, I think this goes back to this notion of disrespect for this president and the precedent that you set in saying, you know, when is the elected president the president of all Americans? And we are behind this president, and we'll work with this president. The election is over.
Mm-hmm. And especially when the president nominates someone who's viewed as a consensus moderate person that has in fact had support before from Republicans. So I mean, to me, that showed that he was reaching out to try to get that consensus candidate.
That to me was the advice that he received.
All right. Anything more? Okay. Our two Solicitor Generals over there. Okay.
Just thank you.
All right. Well, thank you. Thank you all. And we're going to continue, as you can tell. A day doesn't go by where we're not pushing on this in some way, because we believe so strongly in this, not just for the court, but also for our country, for the people that are around this table that try in good faith every day to work in the Senate. And that's what concerns me. Maybe that's a selfish concern, but this idea that, which some of you have expressed about how you just can't, if you do this now, what is this going to mean in the next Congress? What's this going to mean in the next one if people start messing around like this with the Constitution and with a clear arc of history with what's been happening with other nominees? So we hope there's a sea change, and the public is certainly with us. So we think that's going to drive us in addition to these very important arguments that you've made today. So thank you for joining us.